as Americans realize that the Supreme Court, frankly, has always been partisan. I mean, you know, from arguably from the foundation of the Republic, the Supreme Court has been partisan. In fact, John Adams put his Thomas Jefferson's second cousin, John Marshall, a Federalist, a high Federalist, what today we would call maybe a Steve Bannon conservative, on as Chief Justice of the Supreme Court, knowing, knowing that Jefferson was coming in. He did this after he lost the election to Jefferson, and then had Congress shrink the number of members of the court so Jefferson couldn't appoint people. So Jefferson came in and had Congress expand the number of members of the court. I mean, this is how political the court was in 1800. 221 years ago. So, you know, we've always had this myth in America that the Supreme Court was somehow above it all, that the Supreme Court was, you know, like the gods on Mount Olympus. They are neutral arbiters, as John Roberts said when he was at his confirmation hearings. We're just like empires who call balls and strikes. We merely enforce the law. Well, we all know that's BS. It's not true. The Supreme Court makes law all the time. They made law in Plessy versus Ferguson. They created legal apartheid in the United States in 1896. They then, or 1898, whichever year it was. They then struck that law down in 1954 by reversing themselves. They reversed their own law in Brown versus Topeka Board of Education. The Supreme Court invented this whole legal fiction called corporate personhood in the 1880s, and then doubled down on it in 2010 with Citizens United, and then added to it the legal fiction that because corporations don't have mouths, but they are persons, you know, and therefore they have rights to speak. How do they speak if they don't have a mouth? Well, you'd think maybe, you know, their spokesman could walk up to a microphone, but no. They can use money. And if they want to buy politicians, that's just fine. So, you know, we've been watching this for a lot of years. And the court goes back and forth. They supported, laws against abortion, then they were opposed to laws against abortion, and now it looks like they're going to support laws against abortion again. Among other things, that topic has come up a lot today because I invited people to call in about their experiences with the Women's March. And the Women's March had kind of morphed into an abortion rights march. And so people have been calling about that topic. But this idea that the court is not a partisan actor in American politics is a fantasy that is dying right in front of us, and for good reason. The last time the court went down in flames in terms of public opinion like this, by the way, was in 1936, 1937. Franklin Roosevelt, in the previous 4 years, from 33 until 36, he was elected in the election of 32. He took office in March of 33. And then, he was up for re-election in November of 36. So during that period of time, he got a hell of a lot of stuff done. He got Social Security passed, he got the right to unionize passed, he got unemployment insurance passed, he got the WPA and CCC and a whole bunch of other acronym agencies passed that literally put millions of Americans to work on the government payroll, planting trees, building roads, building highways, building dams. But the Supreme Court in the 1937 session, which, by the way, starts today, the first Monday of October, the Supreme Court in the fall 37 session was preparing to take up what was called there was a package of FDRs bills that included Social Security my apologies, there was a name for it that was sort of like the Resolution Trust or something like that, but the court was preparing to take it up, and there was a very good chance that the Supreme Court was going to declare that as they had done so, by the way, they had already knocked down a half a dozen different initiatives of his regarding the New Deal. They were preparing to knock this down too, and it might have included Social Security. And so FDR went to war with the Supreme Court after he won election in '36, throughout, and was inaugurated in January, I believe. We amended the Constitution to change the date. The Constitution used to have the president sworn in March because, it took 3 months to get to D.C. back in the day. They moved that back to January because in '32, when Roosevelt won the election, the country was in such a crisis that Republican Herbert Hoover was incapable or incompetent to deal with, or unwilling to because of his ideology, that we suffered for 3 months longer than we needed to before FDR came in. So anyhow, when FDR came into power in '36, he essentially declared war on the Supreme Court. There were 4 guys on the Supreme Court, led by Justice Robert Owens, or Owen Roberts, I think is his name actually, same as the guy who's the Chief Justice now. He wasn't the Chief Justice, but he was the leader of the 4 horsemen, who were these justices who were, gung-ho to knock down everything, and they had a 5th who would constantly join them, and FDR was seeing, in October they're going to take apart the Social Security Act and other things. And he mobilized the American public. He proposed legislation. At that time, I believe 5 of the members of the court, I might be wrong, it might have been 4, but several of the members of the court were over 70 years old at that time, and maybe even 6. And FDR proposed legislation that would have allowed all the members of the court who were over 70 to remain on the court, but become, quote, members emeritus. And therefore, all of them collectively had 1 vote. Now, this would have gone along with the Supreme Court, or with the U.S. Constitution, which says that once you're appointed to the federal bench, you've got a seat for life. Today, what people are proposing is, just move them off the court and move them back to, the Fifth Circuit, where they, in the case of Alito, where he came from, as long as they're still in a federal court. But anyhow, this was FDR's plan back in '36. And he had huge support for this. Now, the Republicans were yelling and screaming about it. He's packing the court, and it's a scheme, and he's trying to destroy America. But, right-wing editing of Wikipedia and other websites notwithstanding, if you actually go back and read histories of that era that were written in the 40s and 50s, there was every chance FDR could have gotten this done. And Owen Roberts, under all this political pressure, when the court came into session in October, and FDR hadn't gotten his law passed through Congress yet, it was still being debated, Owen Roberts changed his vote and said, the New Deal is constitutional, we're going to go along with it. And over the course of the next few years, all of those guys left the court, all of the conservatives, and FDR basically filled the entire court with his own people, which is why, I would argue, is why the court, overturned Brown v. Board in 1954, or in part of why. But now the Supreme Court is picking up, today's Supreme Court is picking up a whole new set of hand grenades, essentially, political hand grenades. They did this shadow docket decision, basically overturning Roe v. Wade. Now they've got this Mississippi case. They scheduled arguments for that on December 1st. To hear arguments on whether to just end Roe v. Wade altogether. In Mississippi, they're saying that pregnancy will be allowed up to the 13th week, but with major restrictions. I believe it's the 13th week, maybe it's the 12th, but it's the first couple of months, which is a whole lot more reasonable than Texas, but still, it's like with major restrictions. They're going to hear a major gun case, and in this case, this is a New York law that says that if you want to get a permit to carry a concealed weapon, you have to have a reason. Now, it can be a fairly broad reason. I live in a dangerous neighborhood, or I travel, I have to drive through a part of town where, New York is pretty lax about this, generally speaking, but still, they require you to give a reason. And that's been, by the way, approved by that. Heller did not knock that down. That's been approved by the court forever. So they're going after the gun laws. There's a Maine case that says that right now in Maine, religious schools cannot get Maine state tax dollars. You know, following the whole idea of a separation of church and state. And that the court has agreed to listen to. They're taking up another death penalty case, in this case the Boston Marathon bomber, Dzhokhar Sharnev. It was thrown out by an appeals court, and so that, you know, that's being heard, a death penalty. And then also there's a Texas death row inmate's request to have his pastor be allowed to touch him and pray out loud with him in the death chamber, which is kind of an interesting take. And also whether Abu Zubaydah, who was the first victim of the CIA's horrific tortures after 9/11, and is still in Guantanamo, because we don't know what to do with this guy. He's not been convicted of any crimes. He was apparently an innocent guy, but he's trying to sue two of the people from the CIA who tortured him. And the government is saying, no, you can't do that. They have sovereign immunity, or some variation on that. And so that case is going before the Supreme Court. And all of these cases are just politically charged. And it's going to be real interesting to see, how this stuff shakes out. And I think these are going to become major. I think the court itself could become a major issue in the 2022 and 2024 elections. But if the court starts getting real aggressive, like the court did in 1936 against FDR, you know, Joe Biden has this commission that's looking into ways to fix the court. And of course, you know my opinion. We should add at least 4 new justices to the court, and we should term limit them, essentially. We'll see.
This is the Thom Hartmann Program.
Is this going to catch traction? Are the American, I mean, the numbers, the opinion poll numbers are terrible, which is why Sam Alito's out there squealing like a stuck pig.